Oh, it's 8:43 as we welcome Michael Jankins to the desk as it's time to talk a little bit about bankruptcy and some things you may not know about a topic which really has become fascinating.
Well, today I thought we'd talk about how the area of bankruptcy intersects many other areas of law. And so I always like to think that to be a good bankruptcy lawyer, you should have some experience and familiarity with other areas of the law because of these different intersections that are occurring. Real estate bankruptcy has a big impact in real estate law, probate and estate law, divorce law, and personal injury and workers' compensation law. So covering all that, that's almost the entire general practice of law.
Got everybody covered. So how would real estate come into play?
Well, in real estate, if a person is getting sued by a creditor for a medical bill or a credit card or a bank loan, and it ends up in a judgment, the judgment is going to become a lien against the person's real estate that they own in the county where the judgment is. So if we're talking about Polk County, Iowa here, if Citibank decides to sue Jason because he didn't pay his $5,000 credit card, that'll become a lien on his house. And if he has rental property in Polk County, become a lien on that. And so,
but what if he has rental property in Story County?
No, it won't automatically become a lien, and this is just an automatic creature of the law that a lien just occurs. It can be if the creditor knows that you've got real estate there, then they can take that lien and have it essentially registered in Woodbury County, Iowa, or in Story County, Iowa, and then it'll become a lien in those counties too on real estate. And I should probably say what a lien is because maybe a lot of people don't know what a lien is.
Yeah, what is that exactly?
A lien is an interest that forms against real estate, so like a mortgage. So when you have a lien, it gives you rights to potentially force a sale of that real estate. Now, if there's other liens ahead of the lien that you've got, you have to make sure that lien gets paid off before you get any money. So often it's not that easy to enforce a judgment lien if there's a big mortgage with Bank of America that's sitting there first because they've got to get paid.
Right. How many liens can be on a property?
Sky's the limit. Hopefully not too many.
But you're getting in line then, basically.
You're getting in line.
Okay.
And the problem arises when people go to sell their house or refinance their house. Usually they're going to have some equity, and then those liens have to be cleared. Well, in bankruptcy law, there's a special procedure in the bankruptcy only for your home that you can clear these judgment liens off the property. Now, the bankruptcy all by itself doesn't do that. It's an extra measure, an extra step that the lawyer has to do for his client, where we file papers with the bankruptcy court saying our home is protected, in bankruptcy language, exempt. So we want the judge to help protect our exemption by removing this lien that's harming it. Okay. So it's a standard procedure. All bankruptcy lawyers should know it, and it's fairly easy to do. It's essentially making the request, and the creditor who it's affecting gets notice of this. So if they want to object to it, if they feel they've got some logical reason or legal reason to do so, they can, but it usually goes unopposed. And the judge enters an order saying that lien isn't on the property anymore. So
the lien was for naught then?
Well, while there was no bankruptcy, it had teeth.
Okay.
But once the bankruptcy happens and you go through the procedure, you can remove it so it won't harm you in the future.
Okay.
There actually is a procedure outside of bankruptcy to do it too under the Iowa Code. It takes longer, but there is a procedure as well to have these liens removed from the property. And again, I emphasize it's only if it's your home. Okay. Any other kind of real estate, you can't do that with.
Okay.
So that's one area of the law that intersects with bankruptcy. Another important area where there's an intersection is in the area of probate and inheritance. If somebody who files bankruptcy, and this is kind of a big deal, ends up filing, and let's say 3 or 4 months into their filing, Grammy dies, and all of a sudden they become entitled to $50,000 because Grandma had a big amount of money and was kind enough to share it with their grandchild.
Got it.
They lose that money. If the bankruptcy hasn't been on file for at least 180 days, 6 months, then that becomes an asset of the bankruptcy court.
And you lose it.
Or at least that part enough to satisfy all of the debts.
Okay, what if it's after 180 days?
You're standing in tall cotton.
Okay. So
Then you got a nice
Grammy,
payday.
hang on a little bit.
for a
Hang
little
on,
while.
Grammy.
No, pull the plug yet.
Well, and that raises an interesting
Yeah.
bankruptcy planning device. When we talk to our clients and I ask them, are you entitled to any inheritances? Sometimes we get into a discussion, well, my mom or my dad is not in real good shape. They're, very, very ill. Do they have a lot of money? Yeah, I'm going to inherit $500,000. I go, well, we got some issues here.
Right.
You might want to consider talking to your parent and their attorney and potentially having you removed from the will, so that if during your bankruptcy they were to pass away during this 180-day period, the court won't get that. Now you have to put a lot of trust and faith that your share, even though legally you're not going to be entitled to it, the rest of the family will be willing to give you a cut voluntarily. And
That's always great discussions between
when
families.
the states happen,
here's
it gets
the
kind of
question.
greedy.
Yeah.
No, seriously, but can you do this? Say you were in that situation you just mentioned, and you're filing for bankruptcy, you get into the bankruptcy, and now you started it, and it's past that 180 days. And would you then go back and say, okay, put me back in the will?
Yes.
Then you'd be in the safe zone then.
That's a matter of fact, during the planning stages, that's kind of the discussion that occurs. Once the 180 days passes and hopefully father, mother, Grammy's still alive, you need to get back to the attorney who does the codicils to the wills and says, hey, can we get me back on?
Yeah, undo it, yeah.
But yeah, and it's actually, in my practice, saved some people some
Really?
inheritances where they actually did have somebody that passed away, and they were very thankful that they had someone tell them, you might not want to be part of the will.
Wow.
How much time do you need allotted for things like that? Like, is that done in a day to
Well,
change something like that?
It depends. I mean, and there's other factors. The person that maybe isn't in the best of health, has to be mentally competent, because the attorney that does the wills isn't going to change something that they
Just
know the
because you
person's
tell
not
them to.
mentally competent.
Right.
And so that's an important factor. But if they are, it's just a matter of how quickly they can get in with the attorney and do the legal document to change the will. And but then if the 180 days passes, they got to understand, hey, don't forget, get me back on.
Game on.
Game
okay.
on.
Well,
Wow.
interesting
A lot of things
takes
to
on
think
these.
about.
So great stuff there. And people want more answers to some questions. Here's where your office is located.
Just call me at 255-1855. I'll be happy to talk to you on the phone, or you can find me on the internet at www.iowa-bankruptcylaw.com.
Perfect. Wonderful. Great job. Thank you, sir.
Thank you.
All right, it's 8:51. We'll be right back. You're watching